Good morning and welcome to this professional development update. My name is Charles and I have been a solicitor for 40 years. Today we are looking at a judgment that every firm, every partner, and every fee earner needs to understand. This morning, the Court of Appeal of England and Wales handed down its judgment in the case of Silex and others versus Mazur and others. Citation 2026 EWC Civ 369. The headline is simple. The Court of Appeal has reversed the High Court's earlier decision. That matters enormously because for the last 6 months following the High Court decision in Mazur versus Charles Russell Speechlys in late 2025, the profession has been operating under real practical uncertainty about who can lawfully conduct litigation. Today's judgment restores clarity, but it does more than just turn back the clock. It tells us very clearly what proper supervision must now look like in practice. And that is what I want to focus on today. We will look at how we got here, what the Court of Appeal has decided, what good supervision looks like going forward, and the immediate steps your firm needs to take this week. Let me remind you briefly where we were and why the original decision caused such chaos across the sector. In Mazur versus Charles Russell Speechlys in 2025, Mr. Justice Sheldon took an incredibly strict reading of the Legal Services Act 2007. His key findings were stark. He held that only authorised persons can conduct litigation. He ruled that work done by unauthorised staff, even when they were working under supervision, could be unlawful. And he drew a sharp, bright line distinction between supporting litigation and actually conducting litigation. That distinction was not theoretical. It went straight to the validity of the work done. The consequences were immediate and, frankly, disruptive. Across the profession, paralegals effectively lost the conduct of their files overnight. Chartered legal executives found themselves suddenly restricted in their practice. High volume firms, particularly claimant practices who rely on delegated structures, faced massive operational disruption. Law centres and legal aid providers who operate on tight margins with tiered staffing were hit hardest of all, and inevitably we saw the beginning of costs challenges in ongoing cases, with opponents arguing that work done by unadmitted staff could not be recovered. In short, the High Court decision cut across decades of accepted practice. It ignored how modern law firms actually work. Thankfully, the Court of Appeal has now decisively corrected that position. The core holding of today's judgment is this: an unauthorised person may carry out tasks amounting to the conduct of litigation, provided they do so on behalf of and under the supervision of an authorised person. That is the key point. Delegation is lawful, but the court's reasoning matters just as much as the outcome, and there are three specific points you need to take away from the judgment. First, the court clarified the statutory distinction. The court drew a critical distinction between the conduct of litigation, which refers to the day-to-day activities and tasks on a file, and carrying on a reserved legal activity, which refers to the ultimate professional responsibility. The authorised person, the solicitor or the partner, must carry on the activity. They hold the risk, but they do not have to perform every single task personally. The tasks can be delegated so long as the responsibility is not. That is the structural correction that underpins the whole judgment. Second, the Court of Appeal firmly rejected the High Court's attempt to divide work into support versus conduct. Mr. Justice Sheldon had tried to draw a line where none existed in practice. The Court of Appeal recognised the reality of legal practice. Litigation is carried out by teams. It always has been. The idea that a paralegal is merely providing support while only the partner is conducting the litigation is an artificial construct that does not reflect how files are actually run. Third, the court made the historical and practical context explicit. The judgment notes that delegation is a long-standing and fundamental part of the English legal system. The Legal Services Act 2007 was never intended to abolish it. And importantly, Lord Justice Burse acknowledged that the High Court had not been given sufficient assistance on how litigation actually operates in practice. That is a polite judicial way of saying that the first decision simply did not reflect reality. The Court of Appeal has listened to the interventions from the professional bodies and restored common sense. But, and this is the crucial pivot in this lecture, this is the part that matters most to everyone watching, because while the court has restored delegation, it has put supervision front and centre. The key principles from the judgment are clear. Supervision is a spectrum, depending on the complexity of the task and the experience of the fee earner. But at all times, the authorised person must retain control, they must retain responsibility, and they must fulfil their consumer protection obligations under Section 1, subsection 3 of the Legal Services Act 2007. And critically, supervision must be real, not nominal. Documentation is no longer optional. You can no longer rely on informal chats across the desk. You must be able to show on paper or on your case management system who is supervising whom, what specific tasks require approval, and exactly how work is reviewed. The Solicitors Regulation Authority has already indicated that updated guidance is coming, building on its 2022 supervision guidance. But the message from the court is clear. Do not wait for the SRA. Build your framework now. Let me make that concrete with some practical examples of what good supervision looks like going forward. Example 1, issuing a claim. A paralegal prepares and files a claim form. Under the new standard, good supervision means there must be clear, documented authority for that specific paralegal to act on that specific file. There must be a pre-issue review by the supervising solicitor, and there must be documented sign-off, not just assumed permission. Not every single letter or document needs checking by a partner, but key procedural steps like issuing proceedings absolutely do. Example 2, an unexpected application at a hearing. A caseworker or junior fee earner attends a routine interim hearing. Suddenly, an unexpected application arises from the other side. Good supervision means you have anticipated this risk. There must be a pre-agreed escalation protocol. The caseworker must know their defined scope of authority, what they can agree to, and what they cannot. And they must have immediate access to a supervisor. That may include telephone approval from court or pre-authorized parameters agreed before the hearing. This is about anticipating risk and having systems in place to manage it. Example 3. A chartered legal executive running a caseload. A highly experienced chartered legal executive runs files under the nominal supervision of a solicitor. Good supervision here means regular documented file reviews. It means structured supervision meetings that are diarized and kept. It means the supervisor must be sampling the work, proactively checking files, not just reacting when the legal executive asks a question. The supervisor must be able to demonstrate ongoing oversight, not just occasional intervention when things go wrong. This is where we move from understanding the law to taking action. There are 5 immediate steps your firm should take this week. Number 1, audit your delegation. Map exactly who is doing what across your firm right now. Do you know which unqualified staff are issuing proceedings? Number 2, document your supervision. Set out clear reporting lines. Define approval thresholds, what needs partner sign-off, and formalise your review processes. Number 3, review the Mazur period. Look closely at the work done between September 2025 and today. Identify any risk areas where supervision was light and consider potential cost challenges that opponents might still raise about work done during that window. Number 4, brief your teams. Everyone in the firm needs to understand what they can do, what requires supervision, and exactly where the boundaries are. And number 5, monitor regulatory guidance. The Law Society of England and Wales and the Solicitors Regulation Authority have both confirmed further guidance is coming. Be ready to align your new processes with that guidance quickly. So, where does this leave us? The profession can breathe again. The Court of Appeal has restored what most of us understood the law to be. Delegation is lawful, but, and this is the most important takeaway from today, this is not a return to business as usual. The court has drawn a clear line. Delegation is lawful, but only with proper demonstrable supervision. The firms that will be strongest going forward are not those who simply revert to their old habits from early 2025. They are the ones who build structured supervision systems, who document what they are doing, and who can demonstrate control at every level. Because if this litigation has shown us anything, it is this: the way you supervise your teams is no longer just an internal management issue. It is now a strict legal issue. Thank you for your time today. Please ensure these principles are cascaded through your departments and keep a close eye out for the forthcoming SRA guidance. So, where does this leave us? The profession can breathe again. The Court of Appeal has restored what most of us understood the law to be. Delegation is lawful. But, and this is the most important takeaway from today, this is not a return to business as usual. The court has drawn a clear line. Delegation is lawful, but only with proper demonstrable supervision. The firms that will be strongest going forward are not those who simply revert to their old habits from early 2025. They are the ones who build structured supervision systems, who document what they are doing, and who can demonstrate control at every level. Because if this litigation has shown us anything, it is this: the way you supervise your teams is no longer just an internal management issue. It is now a strict legal issue. Thank you for your time today. Please ensure these principles are cascaded through your departments and keep a close eye out for the forthcoming SRA guidance.